7 of our series with Judge Johnstone looks at the key considerations for report and affidavit writing and record keeping. You also had some good advice on what you expect to get in a report and what not to include. Could you share that again now?
Yes. The Court's increasingly seeing reports prepared by NGOs under both 82 and under Section 67, that's supervision reports. Some of the points to remember in preparing these reports are: firstly, there is no need to repeat or set out the detailed background or the detail of the final orders themselves. The Court does not want a detailed history or analysis of the placement or the supervision issues that have arisen. All the Court wants to know is whether, in succinct general terms, the placement is going well. If not, then some details of the actual problems might be required. Essentially, the Court will want to know whether the problems are being satisfactorily addressed, or if not, whether the matter should come back to the Court for review. In general terms, I believe a report should be no longer than 2 pages, unless there are exceptional circumstances that dictate some greater detail. We generally don't want things like school reports, contact reports, or other detailed written material, unless, for example, there's a medical report as to some ongoing treatment or counselling that was envisaged at the outset, just to bring the Court up to date with how that medical treatment is going. What I have been saying to caseworkers generally in relation to their report writing is that it is often helpful to have a succinct executive summary on the first page that summarises the detail, couched in simple language, and, as I've said, along the lines of how you might summarise a case to your partner or a friend or a neighbour at the end of the working day.
You've said that it's vital for NGOs to maintain accurate and current records. Can you provide detail as to what this looks like?
Yes. Can I say at the outset that I'm not an advocate of too much paperwork, because I understand that we want to try and free caseworkers up from doing too much report writing and too much note writing and have more time to get out in the field and actually work with families. But I do encourage the maintenance of careful records. Experience shows that a piece of paper has about 10 times the value of an oral recollection, which is subject to the vagaries of recollection and interpretation. In simple terms, every meeting, every phone call, every conversation should be the subject of a brief file note that records the time, date, place, and the identity of the persons involved. The file note should be made as contemporaneously as possible or as soon as possible after the event as it can be. It should record the essential matters covered in summary form, but if there are issues of particular note or which are contentious, it might be wise to record some more detail. As I said, I'm not an advocate of excessive reporting, but the record should be sufficient. This is as much an exercise in risk management as it is about record keeping. It is a skill to say enough but not too much, which caseworkers develop with practice and experience. It is hard to conduct a meeting or an interview and take notes. It is useful where possible for one person to do the talking and another to take the notes.
What are the key considerations for NGO staff regarding provision of evidence via affidavit when attending court as a witness?
Yes, that's very difficult to encapsulate in a few sentences, but I've made a few notes here about what I thought I should say. The basic rule is just to tell the truth. Be objective and be transparent. Don't hide facts or obfuscate. Don't tailor your answers to suit the department's case or its position. Be yourself. Don't try and second guess the questioner. Just tell the story as you see it. Keep your answers short and to the point, but don't be afraid to express your point of view. After all, you're the person in control of the situation and the expert with the relevant experience. When preparing affidavits, keep the paragraphs short. Preferably you should proceed chronologically, because that's how lawyers think. Group your subject under topics as much as possible. Try and think about what the issues are, that is, what is it the court actually has to decide, and what is the relevant information that you can provide that might help the court in making its decision. When recording conversations, try and use the first person as far as possible, and avoid the use of the third person.
That concludes part 7 of this podcast series. I recommend you take the time to listen to number 8, the final podcast in this series. In this podcast, Judge Johnstone sums up by outlining what he views as the critical take-home messages from our interview.